Approaching 6:21 in Trinidad and Tobago. Hopefully you're not too discomforted by the rains this morning because these are the challenges you have to deal with. And speaking of challenges, there are issues of money laundering and terrorism that many people are dealing with at the moment. And speaking at the Caribbean Financial Action Task Force event yesterday, Attorney General Faris Al-Rawi announced government's plans to seize assets of TNT nationals suspected and or convicted of terrorism and terrorist financing. He spoke on that as well as signaling the government's intention to crack down on money laundering and corruption. Here's some of what he had to say.
The fourth round mutual evaluation for CFATF is an exercise which has seen Trinidad and Tobago being the first member country to be evaluated. And those rounds of evaluations, the fourth round evaluations, go currently up to 2022. There are 27 member states which have to be assessed mutually. Trinidad and Tobago has received what is referred to as enhanced follow-up. It's a measure which says that our anti-money laundering laws, our terrorist financing laws, our laws in relation to the proliferation of weapons of mass destruction, our laws which deal with corruption, which deal with criminality, are not in the best state of efficiency. They are not effective or not technically compliant in certain aspects. Particularly, Trinidad and Tobago is under an obligation in the process of enhanced follow-up to report to the CFATF plenary as to its progress, and the time frame for reporting, the first report, is to be tabled in May 2017. Specifically, it's been identified that there is a need for regulation of our sectors which are deemed to be at risk for money laundering and crime and criminality. And those sectors include the gambling or gaming industries, the credit union, cooperative society entities, the non-profit organization entities, the entities which manage themselves through the laws of trusts, and certain other areas. Parts of our laws need to be reformed as well. Once the evidence has been nailed down, as we've done in one, and gelled together, and there are several that we're looking at right now, the applications will all be presented to the court. The due process must be observed, hence the reason for avoiding pretrial publicity in respect of names and persons, etc. But the fact is, the products have to be put into the system, and the system must go to work.
6:23.5 in Trinidad and Tobago. I think we're coming to the point where when lawyers speak, you need to have English subtitles at the bottom so you could actually understand what they are saying in plain English. But we have Attorney at Law Martin George on the line. Hopefully he can speak to us in plain English about what we've just heard, a snippet of what we just heard from the Attorney General. By the way, the freeze of that picture before we actually started was not deliberate. We didn't intend to embarrass Faris Al-Rawi by having with his eyes closed and his mouth open. That was just a technical glitch. We didn't do that deliberately. Some will say we really did it, set him up. We didn't. Because you know, all your fanatics out there will believe that was planned. But Attorney at Law Martin George, very good morning to you, sir.
Hi, good morning to you, Fazil, and good morning to your viewers, and good morning Trinidad and Tobago. And Faris, I always try to bring whatever clarity I could, and I always try to make it simple in a way that people can understand, because the purpose of the law is not to obfuscate but rather to elucidate and enlighten.
Well, I wish that were true, but we don't have time to go into all of that at the moment. Maybe when I have you here to sit down, just at the same time when we go to light a fire under some other institutions. But what do you understand? I'm sure not just those bit of voice clips and news clips that we just highlighted, you would have gotten a sense of what the AG had to say generally. Basically, is he saying that our legislation is way outdated when it comes to these issues of money laundering and terrorism, and basically we have a lot of work to do to get up to speed?
Well, I think he was speaking, first of all, generally in relation to the FACTA requirement and the fact that we are actually being reviewed in terms of the effectiveness of our legislative framework, not just from a point of view of what is on the books, but how we actually implement the laws. In other words, I think the general idea that he's trying to convey is that, look, even the laws that we have existing, we've not been applying them. So I think that in terms of him seeking to move forward with at least one such application, I think certainly it's an attempt to say, well, look, hey, let us test the system, let us put it to work and, put it in the court and have the court determine the matter one way or the other. So in other words, we may not get it perfect the first time, but at least let's start making some progress towards implementing and applying the law. So I think that is really the idea he's trying to convey here.
But is that really, if I could ask you, is that really necessary given that you would have had other jurisdictions who have advanced the legislation and tested it and done and everything and prosecuted and so on, so that therefore in other jurisdictions all of that would have been done already? Is it necessary to do that here?
Well, of course it is, Fizzy, because remember, when you're talking about the requirements of FACTA and their oversight role, they are looking to see how you, in your jurisdiction, with your legislation that you've crafted, how you are applying and implementing that. And remember, even though you may use a template from another jurisdiction, not everything that applies there would apply here. Like, for instance, if you recall, I think on our last discussion when we were speaking about the parallels between the charges which the U.S. Attorney General had read out in respect of a certain individual here in Trinidad and Tobago. And I pointed out to you that, look, they spoke of racketeering, and racketeering is not an offense listed on the books of Trinidad and Tobago. So there would always be these subtle differences. So therefore, while you may take generalized learning and guidance from other jurisdictions, you have to apply the law as you have it. And I think that's what the Attorney General is attempting to do here. And if I could just say, Fazil,
sure.
I certainly appreciate and applaud the approach taken by this current Attorney General in that he seeks to speak in moderation and in very measured tones, and not to sensationalize or dramatize things unduly. If you understand me, you get the impression that, look, he's saying, look, let's get about the business of the state and the business of the office of the Attorney General without the need for self-aggrandizement or, unnecessarily seeking, to draw attention to himself or praise himself or have, pat himself on the back. And that's important because I've always said, as Attorney General, you are Attorney General for all of Trinidad and Tobago.
I suppose that it's somewhere in between, Faris Al-Rawi, because you had the aggrandizement and the bluster of an Anand Ram Logan and the almost sometimes comatose appearance of Garvin Nicholas, who's very, very calm, almost, as I said, to the point of being seeming to appear comatose, but he has his own style and his own manner. But apart from that, Martin George, apart from how it's being presented, are we really saying that it's going to be, given our legislation, which many people have referred to as archaic, the whole question of the implementation, the enforcement, and all of these issues, is there really cause for concern when we talk about the issues of terrorism, those returning nationals who might have been engaged in activity on behalf of the so-called Islamic State in Syria and elsewhere and so on? Is it going to be extremely difficult if the intention is to prosecute these individuals?
Well, the thing is, Fazil, when we look at the Anti-Terrorism Act, which is Chapter 1207 of the laws of Trinidad and Tobago, I think that can give us some guidance and assistance if it is that we do have the necessary information. Because under that act, they have a definition in Section 3 of the legislation, which sets out a definition of, what is a terrorist act. It sets out what is a terrorist. It sets out what is terrorist property. So they have sought to give very broad definitions, and it does not just relate to acts done in Trinidad and Tobago. So when they describe a terrorist act, they're speaking about something, right? They said it's something that can be committed in Trinidad and Tobago or elsewhere, right? And then you have certain things where they describe a terrorist organization, right? They describe what is property of a terrorist organization. So they've sought to try to broaden the ambit of it, because it defines terrorist act as saying a terrorist act is an act whether committed in or outside of Trinidad and Tobago, which causes or is likely to cause loss of human life or serious bodily harm, damage to property, prejudice to national security, or disruption of public safety, including disruption in the provision of emergency services or to any computer or electronic system, or to the provision of services directly related to banking, communications, infrastructure, financial services, public utilities, transportation, or other essential infrastructure. Right? And then it now links it. It says, for the purpose of advancing a political, ideological, or religious cause. Right? So you have a definition which can be used. So therefore, even in the case of, as you say, returning persons, if it is that they have been associated with a terrorist organization, then there's a definition of a terrorist organization under the legislation, which says it's a legal entity or group of terrorists that commits a terrorist act by any means, directly or indirectly, unlawfully and willfully, participates as an accomplice in terrorist acts or in the financing of terrorism. C, organizes or directs others to commit terrorist acts or the financing of terrorism. So, to my mind, it seems that we already have legislation that covers scenarios where if you have the information that, look, these people have been participating as part of a terrorist organization, and if they are returning home, then I think you can immediately seek to institute prosecution against them and look at all the penalties and punishments set out under the Act.
But just so I could understand, Martin George, given what you've just described as you said correctly, a very wide range and a very broad definition of even influencing the committing of terrorist activities. If, for example, someone somewhere in Trinidad and Tobago at a public event, whether it's a religious event or another type of event, urges people to go to fight for Islamic State, urges people to go and fight for the separatist movement in Barcelona, Spain, or wherever else, or any other part of the world where, or urges people to support groups that have been defined, whatever your opinion, as a terrorist group, can they be prosecuted?
Well, it would seem so, because the legislation speaks of a terrorist organization being a legal entity or group that, and under subsection C, says organizes or directs others to commit terrorist acts or the financing of terrorism. So it seems that you can be prosecuted under the legislation. So I think this is where we need to go. We need to actually look at implementing the legislation and bringing the cases to the court and trying to deal with it to tighten up on the existing loopholes and the existing scenarios we have in Trinidad and Tobago. And I think there are ways that this can be used very creatively to deal with some of our known menaces in Trinidad and Tobago.
When you say when you say very creatively, we just have a couple of minutes left. I just want to get a sense of what you mean as far as creative use to deal with the current menaces as you've identified them.
When I say creative use, because of the broad-based definitions which are set out in the legislation and the penalties, in that it allows you to now go after the property of persons who have been committed, who have been known to have committed these acts, then you are able to enforce some very draconian and serious penalties and punishments, which basically could have the effect of crippling any person or organization that is known to be participating in these types of activities. So I would say that you use the full ambit of the legislation and you look at all the aspects of the definition, and you because you see, okay, like for instance, under the same definition